Separation can be an upsetting experience for everyone involved, including both parents and children. When you separate, you and your ex-partner may need to make important decisions about the future care of your kids. Working through these issues is often difficult and emotionally challenging.
This video gives an overview of how the family law process works in Australia and the steps you can take to work towards coming to an agreement with your ex-partner. It is not intended to be legal advice, and we recommend that you speak to a solicitor if you are seeking specific legal advice.
Many parents make parenting arrangements after separation between themselves in an informal way. There are many advantages to coming to an agreement with your ex-partner as you maintain your decision-making ability and avoid much of the financial and emotional cost of going through the legal system. If you and your ex-partner are able to come to an agreement privately, you are not required to engage the Australian family law system.
However, if you are struggling to reach an agreement with your ex-partner about how you are going to look after the kids now that you have separated, the first step you must take is to go to mediation. This is compulsory for most parents. However, you may be exempt if there has been violence in your relationship, if you fear that your kids are at risk of harm, or there is some other urgency.
Mediation can be arranged by contacting your local family relationship centre or another mediation service provider such as Unifam, Catholic Care, or a private mediator.
If you come to an agreement at mediation, the mediator will help you put it in writing. If both you and your ex-partner sign and date the agreement, it will be a parenting plan. A parenting plan is an agreement made in good faith, which should clearly set out when each parent will take care of the children and how you will make big decisions for the children into the future. For a parenting plan to be valid, it must prioritise the best interest of the children and their safety. A parenting plan gives you flexibility as it can be changed by agreement between you and your ex-partner. However, a parenting plan cannot be enforced by a court.
If you can't reach an agreement at mediation, the mediator will give you something called a Section 60I certificate. This certificate lasts for 12 months and allows you to apply to court for a judge to decide how you and your ex-partner will care for your kids. However, you should remember that having a certificate does not stop you from trying mediation again at a later time. Applying to court should be your last step, as it generally is very expensive, costing thousands of dollars and taking anywhere up to 18 months or 2 years for the judge to make a final decision.
At court, the judge will decide what parenting arrangements they believe are in the best interest for your children and make the final court orders. Court orders are legally binding and significant penalties can apply if they are not followed.
There are two primary considerations that the court must look at when making court orders about children. They are the need to protect the child from any risk of harm, which is given more weight than any other consideration, and the benefit to the children of having a meaningful relationship with both of their parents. The Family Law Act sets out a long list of additional factors that the court must consider and sets out the process by which the judge must come to their final decision.
The judge will also decide about parental responsibility. The term parental responsibility refers to the duties and responsibility of parents to make decisions for their children. The judge may order that this be shared between the parents or given to only one parent.
If the judge decides that parental responsibility will be shared, this will mean that the parents have to work together to make significant long-term decisions about the children, such as schooling and medical decisions.
If the judge decides that the parents should share the parental responsibility, then the judge is required by law to consider whether a 50-50 shared care arrangement is in the best interest of the children and is practical.
However, this does not mean that the judge is likely to make an order for 50-50 shared care. Ultimately, the court will make the order for how much time the kids spend with each parent based on what the court decides to be in their best interest.
In many cases, and especially where there is high conflict or violence between the parents, 50-50 time is not seen as being in the best interests of the children.
If you are considering making an application to the court, you should first seek legal advice. A lawyer can help answer any questions you may have, give you advice about your particular circumstances, and help you with your documents.
If you have any questions about your specific circumstances, please call Central Coast Community Legal Centre on 02 4353 4988.
The content of this video is provided for information purposes only. It does not constitute legal advice and should not be used as such. You should get legal advice from a solicitor if you have any questions about your particular case. The information contained in this video has been formulated with all due care. However, Central Coast Community Legal Centre does not accept any liability to any person for the information we provide here. The information is provided on the basis that all persons undertake responsibility for assessing the relevance and accuracy of its content.